A very good morning, folks. Beautiful day here, or just a few yards away from Saddle Crown Court, just from the front entrance. And it's all happening. Penultimate Friday, I told you jurors could be out in a fortnight. Well, don't take my word for it, but yesterday, the closing section of this trial, of this marathon, started with our ladyship, the judge, starting to give legal directions, and something which we would have thought was going to be a marathon or take an entire day. Our ladyship was done by break time. So legal direction giving, and let me read some of the things she told the jurors. Some of the things that she told the jurors. Number one, she explained why this case as is being tried here in London, despite the three people being Nigerians. Of course, two of them are residents here in London, in the UK rather. Bishop Agama resides in Manchester, Olatimbo Ayinde resides in London, while former Minister of Petroleum, of course, is a resident, is a Nigerian national. Of course, I'm only caught up here when she came for that checkup in May of 2015. So the judge explained that, look, bribery, oil sector, number one, oil is a global business, and that these things happen in the oil industry. And oil is a global business, as you can see, even without the Iranian war, the US, Israeli and Iranian war, that oil is a global business. So whatever happens in that sector, it affects, the global economy. So she gave that and also said that, transactions took place in this country. So, and that English law does apply to whatever you do in this country. And that's the reason why this case, she just gave that foundation again, because many people in their minds are saying, oh, this is Nigerian money. These are the oil money is not UK money. So what is UK's business? So that backdrop was given that oil is a global business, and bribery, if you do stuff here in the UK, whether you are a Nigerian national or you are from any part of the world, what you do in this jurisdiction matters, and English law does apply. And today said that these three defendants, that is a former Minister of Petroleum, or known in court as defendants one, or Diezani and Magweke, Bishop Doye Agana, her brother, and Olatimbo Ayinde. These three people, they are being charged. Their case is being tried under two legislation. That is the Criminal Act of 1977 and the Bribery Act of 2010. And in a direction, I'll go over some now and I'll probably go over the others later. But the key things that she mentioned, is that, look, you must disregard speaking to the jurors after they've been handed over documents to guide them, and say, look, number one is that this case is about bribery. And these three defendants are being charged under English law, as I said. And of course, as she has said to them several times, decide this case only on the evidence you hear in this courtroom number 2 here, which has been the venue of this trial since January. Decide this case only based on the evidence that you had in this courtroom. Of course, as you know, the evidence part of this trial ended last week, and the judge reiterated that now that we are now in the final part. So before the premiership ends, by the time the premiership is ending, next weekend, 24th, we could be out of here. This case could have been decided. Of course, that depends on when the jurors are out and how long it takes them. But back to what happened here yesterday, why the judge was summing up and giving direction to the jurors, said this case must be decided only on what they have had in this courtroom. Do not research it. She reiterated that. Do not research it. Don't read anything about it in the press or online, rather. Only what you heard inside this courtroom. That is what she said they must decide. And point number 2, she listed quite a number of points. Number 22 of that point is that in order to convict any of these defendants, you must disregard any Nigerian custom or practice. As long as that thing was not in Nigerian constitution, whatever any of the defendants had done based on Nigerian custom or practice, the judge said in order to convict any of them on any of the charges, on any of the counts, they will have to disregard any Nigerian custom or practice, which must have been mentioned in evidence, whether when defendant John, whether when the former minister was giving her evidence or where it was cited, they say you have to disregard it. Do it based on what you had. And also, she also mentioned that they should treat this case, the case of the minister, as what will be expected, what a normal person will expect from a UK minister. So in other words, use the benchmark for what is expected in deciding whether she has acted improperly or getting any advantage. You must use the yardstick of what the public or what anybody expects from a UK minister. That was it. And so those directions were given to the jurors. And after the direction were given, let me also read part of the direction that she gave them. Considerations, may join, and of course, part of the count is also conspiracy. So it's not just a bribery. Conspiracy is part of the count. And when giving them direction, she said, look, conspirators, they can join or leave anytime. That means conspiracy is an act to commit crime. It's not actually the crime itself, that it is, and they might join and they might leave at any time. In other words, if I have been told we are going to slap somebody or we are going to assault somebody, whether I was there at the beginning of the plan or after the plan was about being carried out, and I said, no, I'm not part of it anymore, that, or I have left, or I do leave, part of that conspiracy, it is still a conspiracy. You're part of it. So she said, conspirators may join at any time or leave at any time. So that was part of the case, of the direction. And she said, look, it is only them, it is only the jurors, the 12 men and women in this courtroom who have been judged, that it is them that must decide. They must weigh the evidence, and then they must weigh the evidence and be sure of that they are satisfied, and that is when they can return whether a guilty or not guilty verdict for any of the count. Of course, after giving a direction, let me read also part of the direction she gave, that you must not engage in speculation or guesswork. Yes, she also mentioned that to them, that they should not, engage in any speculation or guesswork. If anything is not clear, of course, they can always call the attention of the court to it to get clarification. So she stressed that as well, that you must not engage in guesswork or speculation. And number 41 of her point is that, she did mention also that the prosecution, they have relied on circumstantial evidence. She said, of course, the defense disagree, and then she went on to mention things. And of course, she also mentioned that, look, summing up of the judges of the council is not evidence. So she told them that don't take summing up of what the two sides of the bench will say as evidence. Of course, they are going. So, and we saw that yesterday. So they only brought up the evidence when the Crown started her own summing up yesterday. She was only referring to evidence which they had already tendered and some of the things that the defense had already put as in defense of any of the three defendants. At one point, in fact, the Crown said the evidence, the case, the evidence, the defense of Diezani, she said, is nonsensical. That means you guys, with all evidence that they have, and she also told the jurors, she said, look, the burden of proof definitely is on them. And that, as she has mentioned at the beginning of this trial, and also along the time, during the time that the trial is, of course, still in progress before she closed her trial, she said, look, we are going to prove it. And she started to do that yesterday. Let me read also part of the directions from the judge. It's a bribery. Bribing a foreign official, is in section 6. It's part of, and she, of course, is part of what they are being charged for. And in number, among the direction, she told them how to approach the evidence. How to approach the evidence is part of the direction she gave them. Speeches, questions, and comments by counsel are not evidence. It is the answer of the witness. It is the answer of the witness that counts as evidence. And she said, where there is doubt, they must be able to satisfy themselves. And also when they are in doubt, she also mentioned that character witness, which Diezani got from former President Goodluck Jonathan and also Ambassador Godswill Igali. He said, good character when they get to a crossroad that they do not know direction to go, that good character should weigh in favor of a defendant for a charge for any of the counts. Because if somebody had not committed an offense before, so if they are not sure, it's most likely that person is not going to do that thing. But she said there should be no speculation, there should be no guesswork, and only they alone are responsible for weighing up the evidence and then for arriving at the decisions that they make. And then there was a sort of a flow chart of how they are going to approach the evidence. It's like when this happens, for instance, if any of the counts, you agree that somebody has committed that particular offense, then if the answer is yes or no, if it is no, that is the end of it. But if it is yes, there's further direction on how they should go about it. So the prosecution could not finish summing up yesterday. And to this morning, yesterday it was actually about starting on count three to sum up closing remarks. Remember, as they say in sport, you leave everything out there on the field. So yesterday, as she was summing up, like I said, at one point she said, look, Diezani's case is that, she was giving advice to Kola Lokoto, Benedict Peters and others. She said, that is nonsense. So it was a tough time there yesterday, but as they say in sport, leave everything in the face. So the prosecution definitely is going to leave everything. So she was really telling the jurors, look, what Diezani has been saying, what her defense has been saying, that she was only going shopping to give advice, that is nonsense. That how can you be going shopping? How can you be hanging your artwork in a flat if it is not yours, that, it was for her? So those are the things, those evidence which she relied upon during the trial proper before the evidence section was closed. And also, she also attacked what the defense of Diezani mentioned when they were putting her in the witness box. So those are the things which happened yesterday, I'll be able to go into more details of how the prosecution argued their case. And also, she said letters from DSS, as we know. In talking about Olatimbo, she said, look, Olatimbo too also that when she wrote President Buhari, and then also those accusations against Femi Otedola, that there was no point when they interviewed her, did she mention that she had given 1.3 billion naira, the equivalent of $5 million to Jumebeka Chiku, that the letters she wrote to Buhari, she said the allegations in those letters were just against Femi Otedola. She did not say that she was a whistleblower. She did not mention that she had paid that Jumebeka Chiku, the younger brother of former GMD and the former Minister of State for Petroleum, Emmanuel Kachiku, had asked her for 1.3 billion. So the prosecution, in starting her summing up yesterday, also mentioned that she said, look, it's all Olatimbo is just, her defense is completely nonsense as well. She didn't use the word nonsense, but she said also that evidence also is because she had nothing to say. And she said so because she never mentioned that in the letter she wrote to Buhari. She met Buhari at least once in April of 2016. She said that was not mentioned. She talked about corruption in the oil industry, but she didn't say that Jumebeka Chiku had asked her to pay 1.3 billion naira so that, Prince Momo could get business in the oil, could be restored back to his position in PPMC. And also, so the Crown also mentioned that, said, look, told that in the conspiracy part of the kind that, look, Olatimbo, that you set up Prince Momo with your credit card, you set up that account specifically to be doing shopping for Diezani because you were expecting favors from her. So these are the things which the prosecution started to say yesterday. Of course, she has not finished. And of course, the defense for the three defendants, the defense lawyers, they have to wait for the Crown to finish hammering their clients before they have the opportunity also to finish with their case. So if the Crown finishes a case today, if she finishes her summing up today, then the defendants or the defense will start their own summing up. So that is why we have to wait that. But of course, one thing is certain, the closing, the finishing line, just like the Premiership, is just within sight of less than 2 weeks away. As I mentioned earlier, by the time the Premiership comes to an end of next week, Sunday 24th, we might be out of this place. But of course, first things first, that will determine on when the Crown finishes her case today. And when she finishes her summing up, then the defense too will come up and start making their closing remarks. So I'll give you update later in the day or tomorrow on how it pans out at Southern Crown Court. So take care of yourself. Enjoy the rest of your day.